Now it's time to begin, and we will welcome to the stage the first of our combatants, Justin and John. Please come up. Champerty is an agreement between a party suing in a lawsuit and another person who agrees to finance that lawsuit. And, as we all know at common law, this was illegal. But why? Seemingly because society wanted to discourage lawsuits. Today we ask whether times have changed. Our first resolution is third-party litigation financing should be permitted. Our first debate speakers are Justin Brass and John Beisner. Justin, on my right side, is taking the pro side. Until recently, Justin was a managing director at Burford Capital in New York City. I will skip many of the other high notes from his resume and simply start that years and years ago, he graduated from the best LLM bankruptcy program in the nation at St. John's. Judge Warner should be giving me a hug for that. He clerked for Judge Drain in New York thereafter, and he also was an associate at Paul Weiss and elsewhere for a number of years. John, on my left side, is taking the con side. John is a partner with Skadden Arps in Washington, D.C., where he leads its mass torts, insurance, and consumer litigation group. He focuses on the defense of purported class action, mass tort matters, and other complex civil litigation, and over 35 years has defended major U.S. and international corporations in more than 600 purported class actions in federal and state courts. He has also been active in litigation reform initiatives, including before Congress. We thank you both for agreeing to participate today. Justin, we'll ask you to begin today's event with the pro side of the issue.
Great. Thanks, Doug. The best place to start is really what is third-party litigation finance. And third-party litigation finance is a group of funding methods that rely on funds from third parties instead of or in addition to a litigant's own funds. Now, before addressing the benefits of third-party litigation funding and why it should be permissible, Doug hinted at something that comes to everyone's mind when they hear about third-party litigation finance, and that's champerty. In short, champerty is an ancient concept with roots in Greek and Roman law. It was actually put in place in England when the judiciary was weak, so at the time the wealthy were able to take advantage of the court system while the poor couldn't. In the US, courts were skeptical of champerty almost from the beginning. The first criticism of champerty coming in 1824 in New York State Court. And it was for the very reason that I just mentioned, that champerty was put in place when the judiciary was much weaker, and actually the need for it with a strong judiciary was less important. Finally, in addition to that, the reason why the concept of champerty is dated is also looking at how it was used during the Civil Rights era. In the South, many states strengthened their champerty laws after Brown versus Board of Education because of the success of civil rights organizations funding lawsuits to assert their rights under that case. Therefore, in modern times, third-party litigation funding should be permitted as it has many important benefits. A few of the benefits that I would like to highlight and also talk about go to how champerty is also dated is that litigation finance provides those who may not normally have the wherewithal to gain access to the court system or prosecute a claim a way to gain access by tapping the resources of funders who are more familiar with the court process. Second, litigation finance alters the bargaining dynamics between a plaintiff and defendant no matter their financial background. We are very familiar with this in a bankruptcy context. The playing field becomes leveled for the plaintiff without resources and for someone who is already likely out of the money. And instead, they're going to be able to go against a defendant who does have the financial wherewithal to defend themselves and simply stretch the plaintiff thin in order to force an outcome that is more desired by the defendant. Third, by aligning those without sufficient capital to access the court system, the funder allows the litigant to tap into the funder's accumulated expertise in the litigation process. So those without experience in the court process and would otherwise may be intimidated by it or less likely to pursue a valuable litigation will be able to rely on the funder's expertise. There are other benefits to the litigation process, even for those plaintiffs who have the financial ability to bring their own litigation. In many instances, someone who has been spending their own capital in a litigation will want to sanity check themselves to see whether their own behavior is rational. I've experienced this in 2 instances that I think are relevant here. In the first, a well-funded bankruptcy estate in the United Kingdom wanted to obtain funding to take a matter through trial. The case had already been pending for years, and trial was only a month away. But after prodding from a member of the liquidation committee, the liquidator was forced to seek funding to mainly gain the reaction. Funding was denied due to our analysis that there was troubling precedent that was directly on point. And while the facts of this new case were attractive, it was going to be hard to overcome that precedent. So the liquidator, having already spent years involved in the case and millions of dollars, decided to proceed anyway. The liquidator ended up losing at trial. This is a great example where had the liquidator come to a rational economic actor or a disinterested party first, they may have saved the estate millions of dollars in legal fees. The second example that shows the benefit of third-party litigation funding where a plaintiff does have resources is where a wealthy businessman wanted to sue the private equity sponsor who purchased his business. After spending a small fortune with his counsel, he sought funding to sanity check himself and get insight to whether this was simply a personal dispute for him and not something that a rational business person would do. Again, in that instance, funding was declined. Taking that even one step further into the world of Chapter 7 trustees, there have been recent articles that have highlighted how the Chapter 7 trustee in MagCorp used litigation funding in order to hedge some of his appellate risk in a case that had been pending over a decade. In MagCorp, the Chapter 7 trustee determined that it made sense to obtain cash today instead of risking getting nothing if he were to lose before the Second Circuit Court of Appeals. The trustee hedged that risk by auctioning off a capped interest in the eventual proceeds. In addition, the trustee was on record noting that in the event the case was remanded, he actually had very little resources in order to pursue the case. And on the flip side of that, if he lost, he would still have capital to pursue it. These examples of a disinterested commercial actor coming in to assess the merits of litigation in an effort to determine whether to invest provides valuable insights into litigation. It's litigation that's beneficial to plaintiffs whether they have access to capital or do not. Leveling the playing field, providing a sounding board, all of this for a party about to embark on time-consuming and expensive litigation is a valuable tool and shows why third-party litigation finance should be permissible.
Thank you, Justin. John?
Thank you. I want to start by clarifying a bit the definition of third-party litigation finance. Justin, I think, has it right, but I do want to stress the fact that what we're talking about here is an investor buying an interest in the outcome of the litigation. We're not talking about loans, anything like that. We're actually talking about an investor who, in a way, becomes a real party in interest in the matter. TPLF takes many forms. To my mind, some are of greater concern than others. But as Justin said, the main justification has been access to justice. But is there really a need for more litigation in the U.S. judicial system? Unlike most legal systems, the U.S. already permits contingency fee arrangements. You don't find those in many other legal systems around the world. Unlike most legal systems, the U.S. also has no loser pays doctrine. In most other locations, if you sue and you lose, you're obliged to pay something to the other side. And so the main concern I have about TPLF is that it encourages marginal litigation claims. If you pour millions of dollars and make them available to launch more litigation, that's going to happen, and the bar on when an attorney decides to launch a case is going to be lower. I won't stand here and take the position that all forms of TPLF should be prohibited, but I think it should be disclosed in all cases. And so really the issue for me is, should TPLF be permitted in secret? Why do I say disclosure is necessary? Well, for one, as Justin was mentioning earlier, one reason you need to know is whether the arrangement is legal. He referenced champerty doctrines. There has been a lot of debate in the courts about the vitality of champerty in recent years, but I would note that in the last 3 months alone, there have been 3 state appellate courts that have nullified third-party litigation finance agreements on champerty grounds. The doctrine is alive. And I would add to the justification for it what I'm just talking about. Part of the reason for this is because if you get sued by somebody, you ought to know who's suing you. You ought to know who the real party in interest is, who is going to benefit from the litigation if they prevail. Then there's the question of whether the terms of third-party litigation arrangement allow the funder to improperly take control of the litigation, to take it away from the real party in interest. A good illustration is a recent bankruptcy court decision out of the Western District of North Carolina, the In Re Design Line Corporation case. In that case, the main assets of the debtor were unasserted causes of action. The trustee proposed to sell interests in those causes of action to a third-party funder in order to finance the litigation. Initially, the trustee tried to keep those arrangements secret, but the court insisted that they be disclosed. When they were revealed, those arrangements were challenged on the ground that they violated North Carolina state law because the funder would wrest substantial control of the litigation away from the trustee. The bankruptcy court agreed, placing great emphasis on the fact that the funder had the power to cut off the funding if it didn't like the way the case was going. And so, in part based on North Carolina champerty principles, the fact that control would be assumed by the funder, those arrangements were rejected by the court. There are other reasons to have disclosure. The court needs to know if it has a conflict of interest with the funder. Many of the funders are publicly traded, so the courts need to know if they have a conflict of interest. You also need to know if the funder is present, because if there are problems in the case that result in sanctions, the funder is a real party in interest that ought to be subject to that. Also, in civil litigation, we now have the notion of proportionality in the discovery process. It looks at the wherewithal of a party to pay for its own discovery. Well, you need to know if you have a major funder out there that's contributing to the effort. There are also special issues in some cases, particularly class actions and aggregate litigation where I practice. Indeed, the Northern District of California, the U.S. District Court there, recently adopted a standing order that requires disclosure, at least in class actions and aggregate litigation. It was based in part on a case that occurred out there where it was discovered that the attorney for a proposed class had agreed with the funder to give some of its attorney's fees over to the funder in order to get investment in the litigation. Well, there's a problem with that. Attorneys can't give fees to non-lawyers. It's an ethical problem. And more importantly, the funder, as part of the agreement, got 2% of the benefits that were to be provided to the class members without telling the class members that some of their potential recovery had been assigned. So I think that the fundamental position that I would like to articulate here is, yes, maybe it should be permitted in some circumstances, but third-party litigation funding should not be permitted to exist in secret.
Thank you, John. Justin, your rebuttal?
Great. So to address a couple of those points, let's just start with the control and the notion of control. And I'm going to go a little bit more narrow in terms of how it really applies in the bankruptcy context and why within bankruptcy people should be more comfortable with control if it happens to exist in a litigation funding agreement. The reason is, let's look at DIP financing as an example. There are many instances where cases file, and on the first day a DIP is approved, where a business has to be sold in some fixed duration. And at times, as we've all seen, especially in some of the retail cases, that time period is becoming shorter and shorter, and the DIP lender is obtaining more control, whether it's a milestone as to when a plan must be filed, a milestone for a disclosure statement. And all of those things deal with control of actually the entire case. In terms of litigation funding, we're talking about control over one particular asset and the direction of that asset, and having input on the direction of that asset from someone who is skilled in dealing with that. So I think that's, first of all, where a court can take comfort in comparing litigation finance to other forms of bankruptcy finance, which also ties right into disclosure. And I understand John's point regarding the Northern District of California and the rule as it relates to class action. Class action, I think right now the bankruptcy code has its own requirements that would require disclosure during the course of a case. In the course of a case, we have requirements in 363 saying if an asset's going to be used outside the ordinary course of business, you need to go to the court for approval. So I think that we already have that system in place, and then to the extent it's post the effective date, you default to whatever the standard rules may be, and which makes sense because there's no reason defendants should know the extent of a war chest that exists on behalf of the litigation trust. Finally, just one more point on John's mention of the loser pays. I'm in full support of the federal rules adopting some of the more stringent offer of judgment statutes that exist at the state level. If you look at Florida, for example, their offer of judgment statute would allow a defendant in a litigation that's deemed worthless to file an offer of judgment and then obtain attorney's fees and costs in certain instances.
Just a few quick points. On the control issue, I'm not saying that in all instances, whatever the third-party funder obtains in terms of the contractual arrangement is necessarily bad, but as in the bankruptcy case that I mentioned earlier, it should be disclosed so the court can make that decision. I'm sympathetic to what Justin is saying about disclosing information about the funding arrangement that may give one side or the other a strategic advantage. And it's interesting, in that bankruptcy case I cited, the court said everyone gets to see the agreement, but I'm not going to require that you produce the memos and so on about the litigation strategy. We just need to have an understanding of what the control arrangement was. And that's no different in civil litigation. That happens on both sides. A defendant has to put out under the federal rules whatever insurance it has available to finance the litigation. It has to make disclosures and SEC filings about any reserves that it's taken for the litigation, about the existence of the litigation, what it's spending on the litigation. And so to have some disclosure about the third-party litigation finance arrangement to allow the court to take a look at it to make sure that it's consistent with ethics rules and other requirements is appropriate.
Thank you, John. Thank you, Justin. Okay, now it's time to vote. Go to ABI poll, go to poll.abi.org, poll.abi.org. Doing things a little bit differently this time. We're going to take a quick test question, which we'd appreciate you voting on. Bankruptcy filings in 2017 will rise, we hope. A, B, C, D, and
this
E
is
is no opinion.
100% A.
Okay, less than 10% sounds like it has the winning answer, B. Okay, now that you're all ready to vote on the real issue at hand, the resolution is third-party litigation financing should be permitted. Agree strongly, Agree somewhat? John, you have the wrong audience here. That's we all need money to finance litigation and
Here we
keep us
go.
working.
All right.
All right, is that it? Thank you very much. Thanks, John. Thank you. Great job. Kathy and Philip, if you'd take the stage, please. Section 550 of the Bankruptcy Code permits a court using the avoidance powers in Section 544, 546, 547, 548, and 549 to recover avoided property for the benefit of the estate, unless, and I'll paraphrase, a transfer was for value in good faith and without knowledge of the voidability of the transfer avoided. Also protected, of course, are immediate good faith transferees of the original transferees. Our focus today is on the good faith defense and whether it provides too much protection to those who don't deserve it. The Madoff case may come to mind for many of you. Our second resolution of the day is inquiry notice should play a role in the good faith transferee defense. Our second debate speakers are Catherine Steege and Philip Anker. Taking the pro side, on my right side, is Catherine Steege. Kathy is a partner with Jenner Block in Chicago and co-chairs the firm's bankruptcy litigation practice group. She represents numerous parties in complex bankruptcy litigations matters, including most recently for Wellness International Networks in its case before the Supreme Court. Kathy is the fellow at the American College of Bankruptcy and is also an adjunct professor of law at John Marshall Law School. Taking the con side, and on my left side is Philip Anker. Philip is co-chair of the Wilmer Hale's Bankruptcy and Financial Restructuring practice in New York and has more than 20 years of experience. He has represented, it seems, pretty much every type of party in a bankruptcy case and in out-of-court workouts, and recently played leading roles in, among many other cases, Adelphia, Lyondell, and Tribune. Now, I also wanted to provide a little commentary, a little color commentary, if you will, on the speakers, as I often do, when I have insights, and I wanted to do that today because I did have some insights. I have told you in the past how serious our speakers, our debaters take their roles and prepare, and how some are just determined to win. Now, you won't be surprised to learn that these two, both co-chairs of prestigious groups at prestigious law firms and true litigators, fall into this category. It was given that context that it was somewhat unsurprising that one of the debaters suggested that my introduction to the other debater might include a reference to, and in fact contain certain photos from a Judge Posner case in 2011 that she suggested the debtor's position was, shall we say, illuminated by the photos. Being the fair and partial moderator I am, I of course wouldn't want to do that, but I did want to share the photos with you. So, supposedly to illustrate his position. Thanks. Kareem has put them up, apparently. Welcome you both. Kathy, we will start with you for the pro side of the debate.
Thank you, Doug. The numbers demonstrate why inquiry notice is the correct test of good faith. Each year, thousands of Americans lose their life savings to fraudsters. In 2016 alone, the website Ponzi Tracker reported that there were 59 Ponzi schemes uncovered with total losses of $2.5 billion. The 2016 numbers are not at all unusual. Since 2012, Ponzi Tracker reports that on average 65 Ponzi schemes get uncovered each year with similar volume of losses. All of these frauds typically require one thing to succeed: a bank or other key financial institution who looks the other way, protecting their own financial hides and often getting out of the scam ahead of its victims. Eliminating inquiry notice would promote this ostrich in the sand behavior, ultimately resulting in more victims and more dollars lost. Retaining inquiry notice as the test of good faith would make these financial institutions think twice about looking the other way. And it's for that reason that the majority of the circuits have adopted the good faith inquiry notice test as the test of good faith. Using the words of the Seventh Circuit in the Sentinel decision, if a reasonable law-abiding person would inquire further, then the transferee is on inquiry notice unless he can show that he made a good faith investigation and/or his inquiry would have been fruitless and he would not have uncovered the fraud. There are 4 primary reasons why the courts have it right. First, the courts have read the statute correctly. The only legally sound reading of the term good faith is that it has to mean something different than "I didn't know the debtor was committing a fraud." And this is seen in the language of Section 550B, which imposes on a subsequent transferee both the burden of proving good faith and a lack of knowledge of the voidability of the transfer. If good faith meant only "I didn't actually know there was a fraud," then the second half of that test would be meaningless. And since we assume that Congress means different things when it uses different words, the phrase good faith has to mean something different than a subjective inquiry into the transferee's actual knowledge. The second reason why inquiry notice is the correct test is that history supports that conclusion. The concept of the good faith for value defense is not a new defense. The same defense existed under the Act. And the 14th edition of Collier's, when describing this defense under the Act, described it as follows, quote, "The presence of any circumstance placing the transferee on inquiry as to the financial condition of the transferor may defeat a good faith defense unless investigation actually disclosed no reason to suspect financial embarrassment." To support its point, Collier's string cites a long list of cases dating back to 1906. Congress was presumed to know what the law was when it enacted the code, and if it had wanted to change inquiry notice as the test under the good faith standard, it would have done so explicitly. By not changing it explicitly, Congress intended that inquiry notice remain a factor in the good faith analysis. Third, equating good faith with inquiry notice is the only test that makes any type of practical sense from an evidentiary point of view. Proving a party's subjective mental state is a near impossible task. Fraudsters don't leave written confessions, and transferees who are receiving property when they suspect something is amiss don't leave confessions either. So in all sorts of circumstances, when we have to prove mental state, courts look to objective facts. We don't have to look any further than the same statute, the fraudulent transfer statute, to look at the badges of fraud. These are objective facts that let us inquire into the subjective mental state of the fraudster or the debtor. In the context of criminal statutes that require knowing conduct, courts look at the objective facts, the circumstantial evidence to prove knowledge. They do it in civil fraud cases. Here, those objective facts are just what a reasonable law-abiding person would know. Allowing the subjective mental state, a defendant simply saying, "I did not know," to carry the day, defies these common sense evidentiary rules. Finally, economic policy supports inquiry notice. The party receiving the transfer is in the best position to know whether it's receiving a transfer in fraud. Financial institutions are in the best place to obtain information. They write into their loan documents the right to receive financial information, audit information, inspection of their collateral, and all other types of protections. The reasons why the banks don't act is not because it's too hard or too difficult to get the information. Often what they need to know is right in their own files. Instead, they make a cost-benefit determination. They decide that the occasional judgment down the road is a small price to pay for looking the other way and continuing to make money on the fraud while it's going well, and to look the other way and get out of the scam before the other victims find out. Inquiry notice therefore places the burden exactly where it ought to be, on the transferee to investigate when the facts require it.
Philip?
Thanks, Doug, thanks, Kathy. Let me start with the law, what the law is today, and then move a little bit to policy, really what the law should be. Both support the position I'm going to articulate. I agree with my worthy adversary that when you ask the question what Congress intended, Congress is presumed to know what the law is beforehand. The term good faith is not defined in the bankruptcy code, so Congress has to be presumed to have thought it meant what it has been understood to mean in both federal and state statutes for centuries. The Uniform Commercial Code defines good faith, and I quote, as honesty in fact and the observance of reasonable commercial standards of fair dealing. The first prong there, honesty in fact, obviously focuses on the subjective intent. The second part, observance of reasonable commercial standards of fair dealing, may have some objective element to it, but it's focused on whether you, in this case the transferee, are acting fairly with your adversary, not whether you're doing inquiry into whether it is insolvent or engaged in fraud. The Uniform Fiduciaries Act, which is the principal state law addressing what fiduciaries owe, defines good faith, and I quote, a thing is done in good faith when it is done honestly, whether it be done negligently or not. That connotes what I think everyone in this room thinks of when good faith. People whose heart is in the right place, who have good intentions, act in good faith, even if they might not have been as diligent as in retrospect some plaintiff trustee might think they should have been. Let me make a second point about the law, and it's a critical point here because I've heard the argument of my adversary. This is not about the ostrich in the sand. Those courts, in the securities law context, where securities fraud requires proof of scienter, the courts have pretty uniformly said scienter exists even if you didn't intend to defraud, if you acted with conscious avoidance, willful blindness. You were on notice and you completely ignored the reddest of red flags. So too, courts have adopted the same position in the good faith context, even those courts that have rejected inquiry notice. To quote the district court in one of the Madoff cases, in a case in which it rejected the inquiry notice standard, and I quote, if an investor intentionally chooses to blind himself to the red flags that suggest a high probability of fraud, his willful blindness to the truth is tantamount to a lack of good faith. Now let me move to policy, requiring an even more demanding standard, that it was not on, that the transferee was not on any form of inquiry notice, and that it took all steps that a hypothetical reasonable person would have taken to investigate any supposed red flags, would add layers of expenses on commercial entities and banks. That would make the cost of credit more expensive. It would also burden the courts with endless litigation. As the cases repeatedly say, good faith can't be decided on a motion to dismiss. It can't be decided in summary judgment. It leads to trials, nuisance value settlements, and clogging the courts where bankruptcy courts could otherwise be spending their time focusing on helping honest debtors reorganize or obtain discharge. Moreover, it will be counterproductive to what should matter to everyone in this room. We are reorganization professionals. We know how important it is for companies experiencing financial distress to obtain credit while continuing to do business with them. If the law says that a transferee that pays fair value for what it receives nevertheless stands to lose it, simply if there's any hint that the debtor was in financial distress, creditors and counterparties will be disincentivized to deal with counterparties. It will, let me focus there on what the inquiry notice cases have said. They have said, the cases that my worthy adversary notes, that if you're an inquiry notice of either that the debtor is engaged potentially in fraud, or merely that it's insolvent or in financial distress, that's enough to require you to investigate. Let me make another point, and this is a combination of law and policy. Look at the way the statute reads. To have a defense, you have to both give value and, not conjunctive, and act in good faith. So the estate is whole by the for value requirement. If I buy property from a debtor and I pay $700,000 and it turns out the debtor was the property was really worth $1 million, that $300,000 in profit I got that the debtor overpaid goes back to the debtor irrespective of the good faith defense. The good faith defense tells me I can lose the $700,000 that I actually gave in value. Think about what that means. What you're fundamentally saying is that a merely negligent party has to do more than make its adversary whole. It has to pay what is effectively punitive damages. There is no other area of law that does that. And there's no other area of law that puts the burden of proof, as is the case in this case. This is an affirmative defense. I have, this transferee, the burden to prove that a negative, that I was fully diligent, that I wasn't even on inquiry notice. I submit no other rule of law, no other area of law imposes that requirement, and for good reason.
Thank you, Philip. Kathy, your rebuttal?
My friend across the stage here wants us all to feel sorry for the poor banks and the supposedly prohibitive additional costs they're going to incur if they're forced to look at the facts that are right in front of their face. And there's two responses to this argument. First, who better to bear that expense? The bank receiving the fraudulent transfer, which has a commercial relationship with the debtor and access to financial information, or the debtor's other creditors who may not even know the transfer's taking place? But second, importantly, the bank is really not without a defense here. Inquiry notice is not the same as a duty to investigate under all circumstances. It requires the existence of facts that would put a reasonable law-abiding person on notice that something may be wrong. If those facts don't exist, there's no duty of inquiry and the good faith defense survives and the defendant is found a judge not to have to return the transfer. And when the facts do exist, the bank is not required to uncover the impossible. If the bank makes an objectively reasonable inquiry and cannot uncover the fraud, the bank acts in good faith. My adversary indicates that this imposes a double recovery for the estate and is very unfair to the bank who gives the value twice. That isn't so. The Bankruptcy Code provides a remedy to protect against that double recovery, and that remedy is found in Section 502H. If, in fact, the bank would have a claim absent the transfer, 502H resurrects that claim for the defendant who must return the fraudulent transfer so that there is not a double recovery. Finally, my adversary indicates that the term good faith, as used in other statutes, does not include inquiry notice, and he points to the Uniform Fiduciaries Act. In fact, the authors of that act specifically excluded good faith, and they wouldn't have had to do that if the standard understanding of good faith did not include inquiry notice. And that's the point the 10th Circuit made in the M&L Business Machines case when it rejected that very same argument.
Thank you, Kathy. Philip?
Let me make several points. My adversary argues that in all sorts of circumstances, the law allows the proof of subjective intent or knowledge through the proof of objective facts. She's right. But the conclusion she asks you to draw from that means inquiry notice is the right standard, doesn't follow. She's mixing up apples and oranges. The question before you today is, what is the substantive standard? Is it substantively enough to defeat good faith that I had no knowledge, no conscious avoidance, no willful blindness, I just didn't do as much investigation as someone else should? Or is it that I actually had some knowledge and some ignorance of the facts? That goes to substance. How you prove it is a matter of procedure. Think about the affirmative case for fraudulent transfer, an intentional fraudulent transfer. The standard is intent to hinder, delay, or defraud. But yes, you can prove it through circumstantial evidence. That's a different question. My adversary suggests that good faith has to mean more than knowledge. Otherwise, why would 550B1 use both terms? Again, fair enough, but the conclusion doesn't follow. What that means is Congress said willful blindness, conscious avoidance defeats a finding of good faith, not that mere ordinary negligence does and provides for punitive relief. My adversary does something else that real good advocates do. You try to play on everyone's sympathy. We heard about the big bad banks and financial institutions. Well, a lot of defendants in these cases are mere transferees, and it's not good enough to be able to file a claim. Let's give a hypothetical. I invest $200,000 in the Madoff scheme. I have no knowledge of anything going wrong. I get back $50,000. Under the rule of law she's advocating, I can't get back my $150,000. I have to repay the $50,000 if the trustee can prove that I should have known something was amiss. And maybe the case pays 5 cents on the dollar, so I get $10,000 back. That is an extraordinary issue. Two last quick points. She suggests that when you get to the banks are going to simply put their head in the sands. That defies common sense. First, conscious avoidance will always defeat good faith. Second, banks are in the process of making money. At best, they're going to give up all their profit and break even. And third, this doesn't help their reputation, to say the least. Finally, on the legal definition, let me read to you from Black's Law Dictionary. Black's Law Dictionary defines good faith as something done, quote, honestly, objectively, and with no deliberate intent to defraud the other party. Yet this does not cover a sin of omission, something done or not done in negligence. That is precisely the definition of good faith I am advocating, and precisely the definition of good faith that my adversary is asking you to reject.
Thank you. Poll.abi.org. The resolution is, inquiry notice should play a role in the good faith transferee defense. Agree to no opinion. Agree. Okay, about 57% to about 42%. Thank you both.
Thank you.
Professors Salmon and Markell, please take the stage. Our third debate. With the nomination and appointment of Neil Gorsuch to the Supreme Court, a national debate reignited over originalism, the judicial philosophy that interpretation of the statutory and constitutional text should adhere to the original public meaning fixed at the time it was enacted versus and compared to stare decisis, Latin for let it stand, the judicial philosophy that supports following Supreme Court precedents even when they conflict with the original text. Our final debate is here to tackle that issue in the bankruptcy context. The third resolution is, despite stare decisis, wrongly decided case like Dewsnip should be overturned by the Supreme Court. Our third debate speakers are Ilya Salmon and Professor Bruce Markell. Taking the pro side is Professor Salmon. Professor Salmon is a professor of law at George Mason Antonin Scalia Law School. His research focuses on constitutional law, property law, and the study of popular political participation and its implications for constitutional democracy. In addition to numerous scholarly journals, Professor Salmon has published numerous articles in the popular press, and in his spare time has written a number of books, including in 2016, While Smaller Government is Smarter. Taking the con side is Professor Bruce Markell. While this is not Professor Markell's first trip to our rodeo up here at the Great Debate Stage, and while I think most of you know him from his visits to regional conferences and elsewhere, I will briefly note for the uninitiated some background. Professor Markell is a professor at Northwestern University School of Law in Chicago, and before that, he was a bankruptcy judge in the U.S. District of Nevada for 9 years. In his still earlier life, he was a partner at Sidley Austin in Los Angeles, and he began before that in Los Angeles with then Judge Anthony M. Kennedy who was then at the Court of Appeals for the Ninth Circuit. The last credential seems particularly relevant given the Supreme Court's current makeup and the focus of our debate. He also contributes to Collier on bankruptcy, is the author of numerous articles and 4 textbooks, and is a fellow of the American College of Bankruptcy. Thank you for joining us today. We are honored to have you both. Professor Salmon, I will turn to you to begin our debate.
Thank you. So having written a book called Democracy and Political Ignorance, I should probably start out by acknowledging the limits of my own knowledge here. I'm not a bankruptcy expert, therefore I don't know if Dusnip was wrongly decided. Even if it was wrongly decided, I don't know for sure whether it should be overturned 25 years later. What I do know is that at least as a general rule, courts should be very reluctant to place their own mistaken past decisions ahead of the original meaning of the Constitution, or in many cases also of statutes. And I'll start off with a very basic point. Judges take an oath to uphold the Constitution. They don't take an oath to uphold their own past precedents. And there is a difference between the two. It is sometimes said that the Constitution is just whatever the judges say it is, but we all know that isn't true. The reason why we know that is because we all, in our minds, have a list of court decisions where we think that judges got it wrong. And we couldn't coherently say that if we thought that the Constitution, or the laws for that matter, are just whatever the judges say they are, because then it would be completely incoherent and meaningless to say that they got something wrong. As soon as they made a decision, we would have to conclude that by virtue of the fact they made it, it must be right. Moreover, at least in the constitutional field, there are actually huge costs to wrong decisions. The U.S. Constitution is one of the most difficult to amend in the entire world, so if judges can't overrule their flawed past precedents, we might be stuck with those precedents for decades or centuries, or perhaps forever. And when we are stuck with bad precedents, that can lead to terrible results that undermine vital constitutional rights or vital limitations on government power. There are many examples of this throughout history. I will just mention a couple. Obviously, the history of Jim Crow segregation, the history of severe violations of freedom of speech, and there are quite a few other examples as well. Now, it is not my view that even in the constitutional area, courts should always overrule all wrong precedents no matter what. There may be some precedents which are so well established and have such great reliance interest behind them that the costs of overruling them are just too high, or alternatively, it just isn't politically feasible. The policy behind the precedent is so well entrenched that if the courts were to overrule it, the rest of the political system just wouldn't obey them. There are going to be some situations like that. So, for example, if you believe, as some scholars scholars do, that the 1870s decisions upholding the constitutionality of paper money were incorrect as a matter of original meaning. It probably is too late to get rid of them today. The cost would be too high. But I think exceptions like that aside, as a general rule, we should get rid of wrongly decided constitutional precedents. Things are more complicated in the statutory area. Obviously, in the statutory area, wrong precedents are easier to change through the political process. Congress or a state legislature can enact a new law, and also they're less likely to involve vital constitutional principles or limits on government power. So the costs of these bad decisions are lower. Nonetheless, with statutes, as with the Constitution, it's ultimately the text of the law that judges have a duty to uphold. So they should at least, in many cases, be willing to overrule or modify wrongly decided cases. And there are going to be also some situations where there are actually severe costs to perpetuating wrong decisions, even in a statutory area. It is, in general, going to be the case, however, that there will be a tougher trade-off with respect to statutes than with the Constitution. Here, there may be reliance interests that are significant, and maybe they carry more weight than in the constitutional area because there are other alternative ways to fix this. That said, even though there might be more room, I think, for stare decisis in the statutory area, there shouldn't be anything like infinite room. And in some instances, even if there are reliance interests which counsel against completely overruling a bad precedent, you should still, in the courts, look for ways to limit the scope of that precedent, and maybe even in some instances to deal with reliance interests by overruling the bad precedent prospectively, but not retrospectively. And there are certainly examples of this in both the statutory and constitutional area. So the bottom line is this: courts make mistakes. When they make mistakes, those errors can be really costly, and therefore courts, where possible, should try to fix their past mistakes, not perpetuate them. Thank you.
Thank you, Professor. Professor Markell.
Thank you. And I'd like to thank the ABI, and thank you, Doug, for the opportunity to do the debate. Professor Soman started with a disclaimer that he doesn't know bankruptcy law. I don't know con law. Actually, I think it's aptly named, but I want to talk about stare decisis, and I want to try and make 3 points. First, I think stare decisis, as we know it generally, promotes stability, without which many of the reliance interests that Professor Soman talks about cannot develop. It promotes reliance on those so that lawyers can do what they are paid to do in terms of inform their clients as to the effect of a statute on their lives. That in turn makes the process more efficient. It cautions judges to craft their opinions in such a way that there are no unintended consequences. It is a pressure from the outside to get it right that is not necessarily present if in fact it's an open field day with respect to whether a decision is correct or not. The second point I want to make is a point I think that Professor Soman concedes, which is if in fact in the area of bankruptcy court or courts get it wrong, it's easy to correct through Congress. They created the statute. If they create the problem, they're the one to fix it. Finally, I'd like to focus the debate on where I think it probably should be, which is that everyone acknowledges, and it's hard to debate the point, that you should get rid of bad decisions. The whole point, though, of stare decisis is to keep some bad decisions, because good decisions don't need a rule of law to support them. We need stare decisis because there's a countervailing policy with respect to the stability and the efficiency of the court system. So in terms of starting at first, I was a little bit flat-footed when I heard the topic of the debate. Stare decisis is pretty old. You can go back to 1545 in the time of Henry VI and find judges talking, and I'm paraphrasing now, that you should not kind of vary from the statutes, because then what the apprentices, then the lawyers to be in what passed for schooling, then how would they ever trust what the courts have written if they know that it can be changed by an argument in the next time? From 1454 to the time of Blackstone, we have a development of precedent, and to the extent that someone looks at stare decisis or precedent and says, well, words should have the meaning of the time that they were adopted, Blackstone has a very strong support for stare decisis in his work at that time, and that's what we took into this country in terms of kind of going forward. Now, I should also probably, at a point, as all good debaters try to do, define kind of really what I'm talking about. When I'm talking about stare decisis, I'm talking about what some scholars refer to as horizontal stare decisis. That is to say, if one court can decide it, a lower court's bound by it. That's not what I'm talking about. That's vertical. Horizontal is when the same issue comes to a court with the notion that you may have gotten it wrong last time. No notion of stare decisis is so absolute that it doesn't allow, in certain cases, for revision. Indeed, for the students of history, the English House of Lords from 1896 to 1960, actually in 1897 to 1966, actually did have a rule that they could not overturn a decision. Stare decisis was absolute. That didn't work. We, in America, have always been more pragmatic, and we have, and you can see in our history, that stare decisis is the main driver, but there is always the possibility of revision for, as the court has said, appropriate reasons. So the pressure that we have when we take a look at stare decisis is the pressure to get things right. And if they don't get things right, then the issue comes, well, when do we change it? Well, no less an authority than Justice Brandeis has said that really stare decisis, and I'm paraphrasing here a little bit, is wise policy, because it's oftentimes more important to get a settled rule of applicable law than it is to get that rule right. As bankruptcy lawyers, we know that. Lawyers adapt. They're smart. We can figure out when cases may not go the right way and how to advise our clients appropriately. Especially in cases like Dusnip, I also will call into question the basic notion that it was wrongly decided. Although I've been on record saying I don't like Dusnip, and I think a whole group of people who like statutory interpretation may call it into question, there is a group of scholars and lawyers who say, you know, Dusnip follows the congressional policy of not allowing secured claims to be destroyed in bankruptcy absent the reorganization provisions. They ride through. 506D was intended to do that, and indeed, if you look at the legislative history, it's easy to have that position. So in terms of stare decisis, it's long-standing. It promotes stability. It promotes reliance. It has escape valves. I think we should think long and hard before we reject it.
Thank you, Professor. Professor, your rebuttal.
Yeah. So I'd like to focus on two main points that were just raised in what you just heard. First, the issue of stability. Yes, there is some value to stability, particularly when the rule that is stabilized is actually a good one. On the other hand, if you have a stably bad rule, that could actually be a very bad thing, especially if it lasts for a long time and becomes deeply rooted. There are many such examples in our history. I already mentioned one, the rules of segregation under Jim Crow. For many decades, they were stable and instituted and established, and the fact that they were stable and deep-rooted actually just increased the harm that they caused. So I think it's fine to make stability the prime virtue that we strive for in areas of law where the substantive rule doesn't matter. All that really matters is we have some clear rule, like whether you drive on the right or whether you drive on the left. Doesn't really matter that much which one. What matters is that we have a clear rule that is stable. But in many areas of law, particularly in constitutional law, but also I think in some areas of statutory law as well, the substance of the rules matters enormously, and getting them stably wrong just makes the situation even worse. It is true that there's a long history of stare decisis. There's also a long history of overturning bad past decisions. So the question is, what should be the trade-off between these two? And to my mind, the more important the substantive rule, the more we should be unwilling to keep a bad rule in place just because of stare decisis considerations. Finally, on statutes versus the Constitution, it is true that it's easier to change a bad statutory decision through the legislature, but often it's not that easy, particularly at the federal level, where you have bicameralism and you also have the presidential veto and the like, and you have a lot of gridlock. So while it's reasonable to leave more room for stare decisis in the statutory field than in the constitutional field, the fact that it's easier to correct mistakes through the legislative process, we should not confuse that with it actually being very easy and simple. And on that note, I'm happy to conclude and rest my case.
Thank you, Professor. Professor Markell.
Thank you. 2 points. First, with respect to the constitutional issue, there are some constitutional issues in bankruptcy. Article 1, Section 8, Clause 4 says Congress shall have the power to enact uniform law on the subject of bankruptcies throughout the United States. If Professor Soman would have his way, most of you would be out of a job. Why? Well, there's a very good argument at the time of the adoption of the Constitution. Bankruptcy meant liquidation, didn't mean reorganization. And indeed, it wasn't until 1929, not in a court opinion, but in the Jackson report issued in that year, that finally put to rest a lot of the arguments that you shouldn't keep bringing up the notion that insolvency laws work within the power of the bankruptcy clause. Similarly, do we really want to reopen the uniformity debate? Do we really want to call into question the status of the U.S. trustee because they don't operate in Alabama and North Carolina? And finally, on that point, do we really want to go through the Stern, Arkinson wellness decisions again of the last couple years just because someone thinks that they're wrong? I think not. Last year or 2 years ago in Kimball versus Marvel Entertainment, Justice Kagan said that respecting stare decisis means sticking to some wrong decisions. I think that's a fairly accurate statement. You don't need a doctrine, as I said before, to promote decisions that can stand on their own. And I'm reminded in this respect of the flexibility, the plasticity of the notion that it's a wrong decision or a right decision. Who makes that call? Is it cabin to a particular area in time? I'm reminded of the words in a great movie, A Man from All Seasons. Thomas More is having a debate about the devil. And the opponent, one Roper, says, I would take away all the laws to get at the devil. And Sir Thomas More looks at him and says, you would do that? He said, yes, to get at the devil, I would do anything necessary. He says, well, then what do you do when you finally get to the devil and the devil turns on you and comes after you? What will you hide behind? The devil here is the notion that there are correctly decided decisions. If we get rid of stare decisis, what are we going to do when, in fact, a new generation occurs that sees things differently? Stare decisis promotes stability. Stability is the essence of what we do. And with that, I rest my case.
Thank you. Thank you both. Poll.abi.org. Poll.abi.org. The question is, despite stare decisis, wrongly decided cases like Dewsnip should be overturned by the Supreme Court. Wrongly decided cases like Dewsnip should be overturned by the Supreme Court. Agree strongly, agree somewhat, disagree somewhat, disagree strongly. Please vote. Okay, guys, this is a nail biter. Everybody vote.
This is like Chicago.
I'll give you your iPhone back. Okay. Kareem. 45 agree. 43 disagree. 46, 43. 50, 52, sorry. 46 to 52. Agree. The disagreements seem to have it. Great debate. Thank you so much for coming. Thank you. Okay, all. That concludes our great debates this morning. You have a 18-minute break until the session start. Please check the ABI app. for the programs, and thank you for all coming.